Hi everyone, I'm immigration lawyer John Khosravi. Thank you for joining us today, December 9th, Wednesday, 5 p.m. Pacific, where we have our regular Q&A session. We're going to get into talking about U.S. immigration and take your questions for educational purposes to see what's going on in the system and all the craziness that's happening. If you want to schedule a consultation with my office, please email me at info@jqqlaw.com and feel free to follow all the social media pages where we post samples of approval notices, which will give you an idea about timelines. I know that's an important question. And all this other new stuff that we post about K-1 visa changes that happen, about DACA, about losing your green card for being outside the United States for too much, all sorts of videos and clips. Just follow social media. Links will be in the description below. And without further ado, let's get it started. Yeah, first question, HR Break says, USCIS, that's the Immigration Department, asked me to send an I-693, nothing else. Well, I-693 is the medical checkup you need when you're filing for adjustment of status. So when you're going to file for a green card, there's a medical that comes if you're doing it at the embassy or in the United States. If you're doing it in the United States, it's Form I-693, and that's an evaluation that you get from the doctor that shows you don't have tuberculosis or you treated it, gonorrhea, syphilis, you don't have any mental health issues, you have the vaccines that you need, you're not a drug abuser, all this kind of stuff. And so you go to a civil surgeon, you find that on USCIS.gov, and you put in your zip code and you get a local doctor and you choose one, and you have to submit that with the I-485 adjustment status application, or if you don't, later on they'll send you a letter saying either to send it to us or to bring it to an in-person interview. So I don't know the details of your case, but if they say to send it to them, it may mean that the interview is waived, but not for sure. They could change their minds. So HR, if they literally told you in the request for evidence, RFE for short, to mail it to them, then go get it, mail it to them. Hopefully it does mean that they waive the interview. It hopefully means you'll be getting your green card soon, and we give you congratulations on that. So thank you so much for answering your question. Hopefully success comes your way pretty soon. I got an RFE for an I-944 and I'm in Delaware. That is blocked from it in the December 2nd court order. Okay, no, so the court order that said you do not have to submit Form I-944, what is it called? The public charge declaration of self-sufficiency to show you can support yourself. That only applies right now, the stop of it applies for the 9th Circuit. So these are states like California in the West Coast, California, Oregon, Washington State, Hawaii, Alaska, maybe Arizona, maybe Nevada, I can't remember all of them right now. But if you're in Delaware, you have to submit it. You can try to wait, and they have said we're giving extended time to respond to requests for evidence. So you may want to fill out, have the paperwork ready, but try to go towards the end of the deadline to submit the I-944, because maybe the new administration may cancel it so you don't need to send it, if you want to play that game. If you have good finances anyways, then go ahead and submit it, but I don't know the details of your case to say specific advice, but one tactic might be to wait as long as possible to see if the new administration will be changing things to your benefit. So that's something to check out. Hopefully it does work out to your benefit. When reviewing for work permit, do I use the same form or a different one when renewing? The form for work permit is the same as Form I-765, so whether you're applying for initial employment authorization document or renewal is I-765. Now, some people mistake work authorization based on like an H-1B or an L-1 as a work permit. Those have their own forms, but if you're requesting an EAD, an employment authorization document, the form is I-765, and 6 months or 180 days before it expires, you can renew it as well, and you submit the same form. You just click on a different box on the first page. And depending on the basis of the reason why you're applying for a green card, for a work permit is, you may get an automatic extension for like 240 days. So it depends on what the reason is. For example, if you're getting an EAD based on an adjustment of status, if a green card case pending, you could renew that, and if you submit the renewal before the current one expires, you'll get an automatic extension that'll cover you until the new work permit comes. So that's really important to know. It'll be on the receipt notice for your I-765 renewal filing, and on the previous receipt notice too. On Instagram, ND asks, is the requirement of adjusting status inspected and admitted only required for immediate relatives? No, the basics of adjustment of status is that you have to have been inspected or admitted or paroled to be able to adjust status. There's minor exceptions to this Some people with TPS in certain jurisdictions. Some people have a thing called 245I. There may be VAWA people are, there's exceptions, but in general, this Immigration Nationality Act Section 245A has a requirement of being admitted or paroled to be able to adjust status in the United States. And admitted means you're let in, they checked you out, and they let you in lawfully, even procedure lawful, they went through it. Or parole is that they let you enter for humanitarian reasons. Those are a requirement for adjusting status. So M. Qatar says, I started the marriage green card process. I got a DUI after the fact. How big of an effect will it have? Unfortunately, recently the Trump administration changed the rules and made it more strict on people who have driving under the influence kind of tickets and convictions. It could be very serious. So you 100% need to schedule a time to talk with the immigration attorney, get the documents together, try to get rid of that charge. You will need to bring it up at the interview, but it's something that it's going to work against you, because the government has said the green card is discretionary, so they're going to look at the total case and see what kind of person you are, and potentially an officer could find problems with that. So unfortunately, it's serious. I'm sorry to hear about your situation. It's not good. It's not a game killer for sure, but it's not good, so it's something to think about. Another question is, DACA eligible for I-140 adjustment of status? Well, and DACA is DACA. It's mostly unrelated to an I-140 or I-130 or any type of adjustment status. To be able to apply for a green card in the United States for adjustment status, you have to have lawful entry. So if you don't have that, that's a problem. Now, people have DACA many times came in without permission, so they don't have the lawful entry. So that is a problem right there. So you really need this is serious legal stuff that you need to talk with a lawyer with, because the person who has DACA or who has unlawful entry might have one of those exceptions, or may need to get a waiver, or maybe got DACA before they're 18 and a half, so a waiver is not needed, but they could do what's called consular processing. It's complicated. At the point what the questions you're asking more, I could strongly, comfortably say you need to have an immigration attorney to discuss this with. If you'd like to schedule a time with my office, just email me at info@jqqlaw.com. It's very serious. I do recommend scheduling a consultation with an attorney. Oscar asks, what is non-DACA deferred action for adults? Is it for those who don't qualify for DACA? No. Non-deferred action, deferred action in general is the government saying we're going to hold off on kicking you out of the country, deporting you, or sending you to immigration court. So that's deferred action. Deferred action for childhood arrivals, or DACA, is a specific program that they do that for children that came to the United States. So in general, they have a deferred action that's possible. They might not want to prosecute you. So I had one case where this guy was working as a driver for a company that was doing potentially illegal stuff. And he didn't know, he was just a driver. And they told him, hey, listen, if you research and give us information about the company, then we're going to give you deferred action for 2 years. We won't come after you because he didn't have status, and we'll give you a work permit for 2 years, and then after that, it's up to you. And the guy was, his girlfriend was going to be a citizen soon, so if he got married, he'd file for a green card, so that bought him some time. So he had a deal where he said, okay, I'll help the government out with the fraud investigation, and they gave him deferred action. So that's just regular deferred action right there. Aya says, I sent my adjustment of status to USCIS and I haven't received my receipt note, and the check has been cashed and it's been 7 weeks. What should I do? LA, I'm in the same situation. I filed a bunch of cases 7 weeks ago, still no receipts. It's very frustrating. It makes you paranoid. Like, what's going on? Did they not get the case? What's going on? But it seems they're super backed up. And the last receipt I got took like 5 or 6 weeks to get. But I have like an I-130, a family petition, a couple of adjustment of status, citizenship cases, green card renewals, hitting 6 months, almost hitting 7 months. Still, the check hasn't been cashed. Still no receipts. I don't like it at all. It's made me paranoid, like, did I do something wrong? But I'm getting this all the time. I'm getting messages from y'all on YouTube and everything that are saying the same problems. So unfortunately, this is the situation that we have with them. When I filed my I-130 spouse case, was I supposed to send some pictures of the wedding of proof of marriage or just a marriage certificate? Yeah, when you file an I-130, you gotta send, it's better to send almost always proof of your relationship, which could include the marriage photos. It could include, marriage cards, like you send out to people invitation cards, proof that you have traveled, you visited each other. There's a lot of proof of evidence you should have sent with the I-130. You may get a request for evidence for not sending that kind of stuff, and that'll delay the case. So that's one of the reasons you have a lawyer, just to watch out for that kind of stuff. If you are interested in a marriage green card case, fiancé case, you can find the information you need for most of it in my free no-cost guide, the Ultimate Marriage Green Card Guide. It's the ebook, 41 pages, really breaks down all the basics And then from there, you could consult an immigration attorney if you need more information. Just go to www.marriageimmigrationlaw.com. Again, that's www.marriageimmigrationlaw.com to download it. You'll find the best answers you'll find anywhere, and then schedule a consultation after that to see what's going on. But make sure to type in the www part. Fiancé visas, the initial petition hasn't gone too much longer. It's the same. The problem with Fiancé Visa is that they're not issuing or they're not scheduling interviews in many countries. So I had one where they scheduled an interview immediately. I have cases in China, cases for Iranians, cases in Turkey and Armenia where they're just closed down. And I have a case or two cases right now where they filed a lawsuit forcing the embassy to at least have the interview so they can issue the visa. If the client wants to come in, they have to go and wait in a third-party country, a non-Iran, China, Brazil, or Europe, or England country for 2 weeks before they can enter the United States. Now, those are only for people that are part of that big lawsuit that happened. If you go to my YouTube channel, I did a 10-minute thing talking about what that YouTube is, K1 Fiancé Lawsuit. It's a recent video, check it out. It's a lot of information, so you gotta check it out, see what's going on there. But that's a big problem. So if you were part of that lawsuit, the deadline is coming up. You gotta join it to be a plaintiff if it's appropriate for you, but it's a mess, it's a whole mess. That's why you guys didn't talk about it, because there's a lot of stuff to explain. Jamie asks, I have DACA and want to apply for advanced parole. Would you recommend it? Jenny, in the most cases I would. I need to know your background, because what happens is if you have deferred action for childhood arrivals, DACA, and you enter without permission originally, if you get advanced parole, leave and come back, that is a lawful admission. So let's say you get married with an immigration, if you get married with a green card, a citizen, then you could adjust status and apply for a green card. So it's good to have advanced parole if you did enter lawfully, but you know, if you leave the U.S. with advanced parole and you have any criminal history, for example, when you come back in, they can stop you from re-entering the United States. So it really depends on the case and what's going on. But when this new decision about deferred action for childhood arrivals came Friday night, December, 5th or something like that, I contacted my clients who had DACA, who are going to do waivers. So they're going to file the I-130 because they're married to show their marriage is real, then request a waiver, and then go through consular processing. I contacted each of them, and we had a phone call and said, listen, is there a need for you to travel? Do you have a grandparent that's dying? Do you have like a court case back home? Do you have inheritance that you got to show up for to me? Do you have a school that wants you to send you internationally to do some study or something like that? Let me know, because potentially we could get advanced parole. You could leave with it, come back in, you have lawful entry. Right now you're already married to a U.S. citizen, so then you apply for the green card and you don't need a waiver and you don't need to do consular processing. Two nightmares of things to do. Waivers take forever, cost a lot of money, not reliable. Consular processing, you got to leave the U.S., go to embassy interview, takes forever, costs a lot of money, can still get denied and get stuck outside the United States. So for most cases, advanced parole is recommended, but Jenny, I can't say I recommend it for you or not without reviewing individual case. Everything here is for general information purposes. I love you asks, my wife, U.S. citizen, applied for me and okay, I'm working on cash. Does this bother interview or green card? Generally speaking, if you married a U.S. citizen and you are working without authorization, it's something that's not an issue, it's waived. You know, Trump administration recently said, you know, it's discretionary, but overall the statute said that's not a big deal. Just make sure you didn't claim to be a U.S. citizen to get that job. You didn't lie about something, some sort of fraud documents or something like that. Overall, it's not an issue. Every case I have, if I know or the client tells me and I know that they work without permission, I put it on the application when they're married to a citizen, because that's not a problem. If they're not married to a citizen, that violation is very rarely. There's some exception. There's always exceptions, but for the most part, that's something that'll prevent them from getting a green card. So it's not a case I would submit. But generally, married to a citizen, it's not something to focus on. Thank you everyone who joined us on our live session every Wednesday. Again, the marriage green card ebook, go to www.marriageimmigrationlaw.com and download the ultimate marriage green card guide, and it'll break down the process for you. Thank you, user14 says, thank you very much. Be safe. God bless you as well. And contact my office, info@jqqlaw.com. I have colleagues that can help you with all sorts of cases, just trying to do the best to give you the good advice. I had a citizenship case call today, consultation, where the guy could have filed for citizenship, but there were some issues that were problematic, and I just gave him an honest answer. I said, wait another year, see what the situation is. There's no rush. You get that. My goal is to give a good, honest answer so people have a good idea based on my knowledge and my interpretation of the law. You go to different people, they'll tell you different things, but I always think, well, if I was in this person's situation, what would I want to do and what advice is good for me. And that's why when the consultation, that the meeting is so important, because it's not just the legal stuff. I got to know what's going on in your life, what's important to you, what's going on with your family, your business, your work. So I could, take all that information, non-legal stuff, into consideration to say what is best for this person, in their lives and what is important to them. And so I could really see every factor. And that's what I do in my consultation. So definitely just email me at info@jqqlaw.com. and we'll see what we can do. Azim, thank you so much. As you say, I know a lot about immigration, and you certainly give the best answers. Thank you, Azim. God bless everybody. Have a great Wednesday. I'll see you all next week, 5 p.m. Pacific time, live on Instagram, JK Law, on TikTok, Immigration Lawyer John, on YouTube, the JQK Immigration Law Firm. Also, one last thing. I've always posted a lot of clips on the JQK Law Firm page. They're short clips, they're answers to the things I give. I've made a separate page called JQK Immigration Clips. We'll find shorter clips, and I'm only putting the longer form material that are like, 7, 10, 15 minutes on the JQK website. So definitely subscribe to that second page. We have a lot of subscribers on YouTube. You can subscribe on that page as well. Will be cool. I guess with that, thank you so much to you all. Next week. Bye-bye.